Welcome back to the Farm Show on Westplex Talk 1045. Before we went to break, we were playing select clips from an interview between USDA Deputy Secretary Stephen Vaden and a gentleman from the National Agricultural Law Center. The gentleman's name is Harrison Pittman. You can find this entire interview by going to the YouTube page of the Arkansas Division of Agriculture. A number of enlightening comments here from the Deputy Secretary, including some comments on biofuels. Have a listen.
I would be remiss if I did not mention that we need a proper biofuel policy to open up domestic demand. The Secretary has endorsed E15. She did so most recently at the Farm Bureau convention out in California. We need Congress to pass that. That's going to instantly result in at least 50% more corn usage for ethanol, meaning millions of more bushels will need to be purchased from American farmers to meet that increased biofuel demand. We've got a great partner in Administrator Lee Zeldin and his team at the Environmental Protection Agency. They've got a proposed rule out now, the RVO rule, which looks at blending requirements for both ethanol and biodiesel going across the next couple of years. The targets that they have set are aggressive, some of the most aggressive that have ever been set. But what's equally critical is that for the first time, the EPA is proposing to make those targeted numbers, which make the headlines, real. Because they're proposing, again, for the first time ever, to reallocate volumes that have been waived through the small refinery waiver exemption. The courts have interpreted that exemption. They've tied EPA's hands and say, if a small refiner which meets the following criteria, which the courts have defined, and they've defined both small refiner and the criteria, EPA has no discretion, essentially, other than to grant the waiver. What has historically happened are those waived volumes of biofuels that those small refiners could have blended essentially drop out of the equation. No one ever produces them. No one ever blends them into our petroleum fuels. And so the bushels of corn and soybeans that are necessary to create those biofuels are never purchased, depressing the price. What the EPA has proposed is simple. Okay, fine. If you're entitled to small refinery waiver, you'll still get it. But we're going to take those volumes that you would have blended, and we're not going to allow them to fall out of the system. Instead, we're going to reallocate them to the larger refiners, which are subject to the blending requirements, and they're going to have to blend those amounts on top of their normal requirements. So the volume will not fall out. Those bushels of corn and soy will end up being purchased, and farmers will see the benefit. For the first time ever, that top line number, which gets so much attention as to how many gallons of biofuels we need to blend, it'll be true. And that's saying something, and that will make a difference.
One of the hottest topics here in the state of Missouri right now, as it relates to agriculture, involves glyphosate. You know it by its branded name, Roundup. Legislation from State Senator Curtis Gregory and State Representative Dane Deal address the topic. On the national level, the whole package of legislation is generally known as failure to warn. You know that USDA has a position on it. Spoiler, you're going to hear about judicial hellholes and something called jackpot justice. Tell them, Stephen.
Well, first, I want to say something that as a lawyer myself, I know lawyers don't hear much, and that's thank you to the team at the Department of Justice, because as you noted, they filed a brief recommending the Supreme Court take this case to resolve the circuit conflict, and they came in on the side of American farmers. They said American farmers need Roundup and other chemicals in order to grow what not only the United States, but the rest of the world eats every day on their plate. And federal law is clear. EPA regulates what goes on every chemical label. 12 people on a jury in specially selected judicial hellholes that trial lawyers know so well don't get to regulate it. And that is the genesis of this whole issue. We have the EPA relying on decades and decades of scientific study, which shows that the label that they have approved is sufficient to tell farmers how to use the product without harming themselves or the environment or anyone else. And we have that being second guessed by juries located in jurisdictions specially selected by trial lawyers who know where there is a jury pool that is more than willing to engage in jackpot justice and listen to them weave their tale and then write incredibly large numbers down on the verdict form. And those two things cannot coexist in a world where the statute is clear that it is EPA that regulates these chemicals. And I know you have all types of listeners, Harrison. Anyone who has ever reviewed EPA's review process, much less any registrant that seeks to go through it, it is a lengthy process that takes years of studies, review, and approval to get any chemical approved to go on the market. And then once that chemical is approved to go on the market, EPA has to review and approve the label that goes on it. This is not a quick process. It is not uncommon for a chemical to be under study and under review by the EPA for 10 years or more before they approve a new chemical to come onto the market. So anyone who is suggesting that there is a slipshod process that is overseeing what are the tools that our farmers need to grow the food that we depend on every day is just not educated themselves on EPA, its expertise, and how difficult it is to get any chemical through this process. And so given the amount of investment that it takes, the untold millions of dollars that they have to invest in these studies, not to mention the time to get a chemical approved, to allow state court juries in specially selected locations around the country to second guess EPA scientists on the basis of little to no evidence whatsoever, it's throwing the entire congressional statutory scheme into doubt. And so I'm glad that the Supreme Court saw that. I'm glad that they took the Solicitor General's suggestion that they hear this case. And I hope they'll listen very carefully to what Solicitor General Sauer and his team have to say as this case is briefed and argued, because this really could make the difference in between whether America is able to retain its status as the innovation leader in agriculture, or whether we potentially have a threat to lose that crown because we're going to let juries second guess PhD experts who've spent decades at this work.
There's also been a whole lot of talk nationally about right to repair laws. Here's what Vaden had to say.
Well, the answer on right to repair is clear and direct. This administration thinks farmers should be able to repair their own equipment, and industry's efforts to prevent them from doing so are illegal. That's why this administration's Federal Trade Commission is currently suing John Deere and some of the fellow equipment manufacturers to stand up for American farmers' rights to repair their own equipment and to not to have to suffer under a system where when their equipment breaks down in the field, they have to call a John Deere dealer, for example, and wait for them to send out someone to fix a simple issue that the farmer can repair him or herself, costing them time, productivity, and money. And that issue is symptomatic of a number of the issues that we're seeing. I mean, this is an administration. We come from a more conservative perspective. We believe in the free market, and we don't see antitrust conspiracies around every corner like some of our colleagues on the other side of the aisle do. Having said that, antitrust laws exist for a reason. And that reason is because when an industry gets too concentrated, that is to say, there are too few people competing, bad things can happen that undermine free enterprise. And there are signs that that may be happening in American agriculture. That's why President Trump has signed at least 2 executive orders asking USDA to work with the Department of Justice and the Federal Trade Commission to investigate these antitrust concerns. And one of them, as you've quite rightly noted, centers on equipment manufacturers. And it's not just the right to repair, it's the right to pick which dealer you purchase from. I mean, ask any farmer who's bought a piece of equipment recently. Can you pick which dealer you want to purchase from? The answer is no. I mean, if you were to ask the equipment manufacturers, they'd look at you, smile, and say yes. But what they wouldn't be telling you is that if you should happen to pick any other dealer than the one they designate as your local dealer, they'll charge you more for the same piece of equipment, the exact same piece of equipment. There's a financial penalty, which is prohibitive to your exercising choice over which dealer you use to buy your equipment, eliminating the ability to compete on the basis of price. And then once you purchase that piece of equipment, as you've rightly noted, Harrison, you don't have the right to repair it. You've got to have the implement dealer be the one to repair it. And when they do repair it, they will only use original manufacturer equipment parts, which cost more. So all of these three things, when added together, limiting your choice of where you can buy, and then when you have purchased the piece of equipment, preventing you from repairing it and preventing you from using anybody else other than their own parts, give them more pricing power and allow them to drive up the cost of not only purchasing the equipment, but of ownership and operating the equipment, all which goes directly to their bottom line.
Vaden also had some strong words about the fertilizer industry.
And the duopoly that is Mosaic and Nutrien, and their successful efforts over the past several years to constrain fertilizer supply in this country and drive up the costs that farmers are paying. Now, I'm happy to say with regard to fertilizer that Mosaic and Nutrien have been so lazy in regard to their own investments that they have actually enticed, economics seems to be working here, they've enticed a new private sector participant to come in, invest $13 billion of their own money in a new mine located in Saskatchewan, Canada, that next year in 2027 is going to begin exporting to the United States of America and break up that duopoly's control over how much can be imported in here. It should have never been allowed to happen in the first place, that those two companies were able to so constrain the supply of so many of the fertilizers our farmers depend on that they were able to get pricing power. And if you think that some of what I'm saying is not grounded in fact, let me just take fertilizer as an example. Mosaic and Nutrien have a joint venture in Canada where they openly, their word work together, my word collude, to control prices up there. That would be such a clear violation of the antitrust laws of the United States. They don't bring that joint venture officially down here in the United States. But what they've been able to manage to do through other means is achieving the same result, constraining supply and driving up the price that farmers pay. It's unacceptable. This administration is going to do everything it can to ensure that farmers have the fertilizer it needs to at a price that they can pay and a price that allows food to be purchased at a price the consumer can pay. And we're not going to allow these two companies to do anything to undermine this or any other new market participant that wants to come in, provide new fertilizer supply, and break up the cute little game that Mosaic and Nutrien have been playing for the last several years.
And another big topic right here in Missouri has been foreign ownership of farmland. Here's what Vaden had to say.
An interesting fact that our national security team at USDA and across the federal government will tell you is that when it comes to certain countries' desire to own farmland in the United States, they appear to believe that the most fertile farmland is that located closest to America's military installations. And that, in a nutshell, is why we need to pay such close attention to this issue. I know you recall, Harrison, that back in the previous administration, a foreign company wanted to buy land in North Dakota near one of our critical military bases up there. And the previous administration claimed powerlessness to do anything about it. And so the city council of Grand Forks, North Dakota, had to step in and stop the transaction. Now, first of all, hats off to the city council of Grand Forks, North Dakota for doing something. I'm sorry they had to do it, but thank God they were there. But as a result of that, Congress stepped in and made the Department of Agriculture a member of the Committee on Foreign Investment in the United States when it comes to land transactions. And that's on top of the fact that since 1978, that statute you mentioned, AFIDA, the Agriculture Foreign Investment Disclosure Act, has required anytime a foreign person comes in possession of farmland here in the United States, they are required to register with USDA. Now, in all honesty, over the past nearly 50 years, that statute has probably been ignored more often than it has been followed. But if you read the text of the statute, it contains some pretty clear requirements, registration, and also some pretty severe penalties. It allows USDA to fine someone who fails to register their foreign ownership of agricultural land here in the United States up to 25% of the purchase price of that land. Now, what we're doing under Secretary Rollins' National Security Plan, which she rolled out on just my second day here, the 8th of July of last year, we're modernizing how we administer the Agriculture Foreign Investment Disclosure Act. We're going to make it easier for foreign owners of land to register by moving it from a paper process to a modern computerized process. It will also allow us to have better access to the records and be more able to accurately respond to inquiries from our fellow cabinet agencies as well as Congress about foreign ownership of land. But as a part of that, we're also going to get serious about enforcing those penalty terms, which means that if you don't file under AFIDA, you're going to get fined, and that fine is going to be substantial. So we're going to expect compliance as part of this. We currently have out for public comment an advance notice of proposed rulemaking. If you're watching this broadcast and you are a land broker or someone who frequently deals as a lawyer in transactions involving ag land, I encourage you to go to the Federal Register, look up the end of last year, around the 30th of December, I think it was, and take a look at that advance notice of proposed rulemaking. We've got an explanation of the policy ideas that we have, and then we've got a series of questions that we want feedback on from people who are involved in agriculture, who are involved in the sale and purchase of land, and the information that you provide us in response to those questions that we've put out in the Federal Register are very quickly going to lead to a new rule that we intend to propose and finalize this year that will modernize the Agriculture Foreign Investment Disclosure Act reporting and penalty regime. But we need feedback from all of the intelligent people who are watching this today, who are involved in these types of transactions every day, to help us be able to center in on what information we need and what the most efficient way for us to collect it is, so that this new regime can be a benefit and not a burden to productive agriculture here in the United States.
All right, we got to leave it there for today. Again, that was the National Agricultural Law Center tackling some of the biggest issues that we see here in the state of Missouri and nationwide. If you want to hear the full conversation with USDA Deputy Secretary Stephen Vaden, check out the Arkansas Division of Agriculture on YouTube. That's all the time we have this week. We'll see you right back here next week on Westplex Talk 104.5 at 10 a.m.